He's the former federal prosecutor. Now he works the defense side of the table. How about it for David Katz, everybody?
Great to be with you guys.
Yeah, thank you so much, David. Well, I want to check off at the end here on a decision that was made at the Supreme Court level to, now maybe we can just do it quickly, David, if you wouldn't mind. It doesn't relate to Trump, and it doesn't relate to a conspiracy to overthrow any kind of election. It relates to women's reproductive freedoms and that pill, that abortion pill that is embattled right now. It's been the source of a lot of controversy. Sort of, it's viewed as the next front in the abortion battle. Can you speak to what the Supreme Court just decided in this case?
Well, I think this is the Fifth Circuit Court of Appeals, right? In the
the Fifth Circuit. Okay, I see. Yep.
This is the case that started in Amarillo, Texas. It was judge shopped to the friendliest judge for the right to lifers, probably in the country, a Trump-appointed judge who used to actually be with a right to life, so-called advocacy group. He was put on the bench by a very narrow vote after nominated by Trump. They shopped this case to him, and he basically ruled that this medical abortion pill hadn't been properly approved by the FDA. This was earth-shattering because no FDA decision like this had been stricken or struck down. And the pharmaceutical industry got behind this because they said, you know, if it can happen to this pill, which is controversial regarding abortions, it can happen to all kinds of things, diabetes medicine, COVID medications, you name it, it could happen to it. So Big Pharma is on the side of the angels on this one. They're fighting to protect the rights of the manufacturer of this medical abortion pill. That case ended up going up to the U.S. Supreme Court because the district judge there put in place an injunction that would have stopped access to the pill, not just in red states, but in blue states. He entered a nationwide injunction. The U.S. Supreme Court threw out his nationwide injunction, and they said there will not be an injunction until this U.S. Supreme Court rules on it again. But the issues are kind of complicated. Why don't we let it go to the appellate court? We're going to dissolve this stay. We're going to let people still have access all over the country to these pills on the same bases they were allowed before. But we're going to let the case proceed to appeal in the Fifth Circuit. And if you don't like the Fifth Circuit, and if you don't like Trump's appointments, this was one of the worst. You had the Clarence Thomas, you had the Stanford-educated Clarence Thomas law clerk named James Ho, I think is his name, Federalist Society through and through. He would have gone further. He would have actually backed up everything that that judge in Amarillo, Texas did. He would have thrown out the FDA approvals of the drug way back 20, 25 years. Fortunately, the other two didn't go that far, but I think it was very unfortunate too. Another one was from Trump, one was from Bush, and they said, wait a second, the recent decisions that the FDA made about this abortion pill, and this is how more than half the women in America get an abortion, not what we may think of with a procedure at a doctor's office, but by taking this pill within a short time of finding out that they're pregnant. They would basically ban the recent decisions. Now, the recent decisions by the FDA are that you can do it by telemedicine, which means that you can call a doctor on the phone. You can get it sent to you through the mail, and you don't have to have a face-to-face prescribing by the doctor. So what's the net effect of all of that, Mark, if this Fifth Circuit, I believe, very right-wing, very non-precedential decision stands? It would mean that all over the country, you couldn't get it, but the bite would be even worse in the red states. Those red states where there aren't doctors around, where clinics are being threatened all the time, where they make you drive 200 or 300 miles to see a doctor, that would all be back into effect because you couldn't get the procedure. They make it so hard for you. And you also couldn't even get this medicine, this pill, because you'd have to drive to a doctor, see the doctor face to face, couldn't have it mailed to you, and couldn't have it prescribed to you by telemedicine. That's where we are right now if the Fifth Circuit decision stands. But the good news is that, as I said at the beginning, the stay was dissolved. And so none of this affects anything at the moment. This case will go back to the U.S. Supreme Court. It will involve all of those issues. It may be right during the 2024 election. Already there's going to be a huge turnout of Democrats and independents to vote on this issue since Roe v. Wade was overturned in the Dobbs decision. This is just like, you know, this is like two more hammers in the coffin. I think there'll be a huge turnout of people who are concerned about this issue, concerned about a woman's right to choose. And if this decision comes down the other way, if it comes down the way the Fifth Circuit just ruled, Mark, there'll be an absolute uproar. Because again, let me say this, more than half the women in America, blue states, red states, get an abortion not by a procedure, but by having this pill normally prescribed by telemedicine sent to them in the mail. They take it at home. It's 2 steps to it. And they won't be able to do that if the U.S. Supreme Court decision stands. Yet, if the U.S. Supreme Court agrees with the Fifth Circuit that just ruled the way I said.
And just in general, because this seems as though, based on what you've just said, to be the case, especially when you talk about, the Clarence Thomas clerk who's now ascended into this judgeship, et cetera. These are reverse engineered decisions, right? They've already decided they want to block all of these things or whatever it might be. But in this case, it's this pill. And they're just going to find the way to do it. And in this case, it received approval in the wrong way. Isn't that right, David? It's reverse engineered.
This is rich, Mark, because it's a female judge who wrote the decision. She says she's helping women. Oh, how wonderful for women to be helped in this way. Poor, often minority women, women who are desperate, women who are 16 or 17 years old, women who are trying to do family planning. All they want to do is to take a pill at home, which is incredibly safe and effective. The reasoning goes like this, that the FDA considered each one of those individually. They considered telemedicine. They considered having it sent through the mail. They considered the fact that it could be prescribed without someone doing a full, clinical examination. But they said the FDA really hadn't considered them all together. And when you look at the effect of all of them together, oh my goodness, a woman's health. And they never stopped to analyze and say, wait a second, compared to what? Compared to having an unwanted pregnancy, compared with the risks of pregnancy, especially an unwanted one, especially one by a poor woman, a woman without many resources. Really, the pill is more dangerous when it's been proven to be totally effective. It's more dangerous than carrying the baby to term involuntarily because the law won't let you take the pill. That's just, that's what's so frustrating about these cases, because the normal balancing that goes into it, which is based on expert opinions. I mean, the FDA has expertise in this. And this is this whole right-wing, regulatory thing by the courts. They do this with environmental cases. And all of a sudden they say that these expert agencies got it wrong. Sure, these agencies are bureaucratic. Sure, sometimes they're captured by, big industry like Big Pharma. But my goodness, I mean, this is a really major decision. Just about every pharmaceutical company in the country has come out and said, this is madness. We will not invest billions of dollars in these drugs. We're not going to invest in things that are going to cure and help people if then the case gets shopped to some crackpot judge somewhere and then to the most conservative circuit in the country that doesn't like this type of medicine for whatever reason, but it's not medical, it's not scientific. We are not going to invest billions of dollars in this just to have our whole campaign to market the drug then thwarted by selectively bringing the case around the country. And that is why I believe that, we talked about this before, is that right-wing conservative majority on the Supreme Court, is it more theocratic or is it more economic? And I think they're going to be more economic. They're going to back up the huge investments and payments by the pharmaceutical industry and not the theocrats. I think we just had a very Fifth Circuit theocratic decision. And it's this Fifth Circuit. It's this Fifth Circuit that's down in Texas and Louisiana. It was bad enough, Mark, and now it's been packed. I'll use the word packed. It's been packed with Trump appointees, Trump nominees.
David, I want to get to Donald Trump, and I want to get to the entire case and dragnet associated with all of his alleged co-conspirators. The news that you broke here, I thought, when you joined us earlier in the week, and you were so good to join us as it was all happening and the indictments came down. For those who might have missed it, I wonder if you can just review the timing, because as excited as everyone is about this, it really will be nothing more than a backdrop, the ramp up to the case, which you had said, as I recall, and please correct me if I'm wrong, won't make it, especially the Georgia case, won't make it in time for the election.
Well, I don't think that it will. And for several reasons, I think, more corroboration for that. The California State Bar is trying to discipline and maybe disbar Professor Eastman. He was a law professor in Orange County, and he gave this real oddball advice. And some people say that it was really criminal, and they say it's worthy of discipline because it was so far-fetched and was kind of part of this plot. And the arguments come up that, well, let's see how the criminal trial comes out. Let's see how the Georgia trial comes out. I guess he wants a stay or a delay of his bar proceedings. And the California State Bar, an official agency, came back and said, are you kidding? That trial won't go for years. So it's not me saying that I don't think that Georgia case will go for years. It's that I think that people who really are trying to figure out for their own docketing and their own purposes have figured that out. One thing that's going on right now, Mark, which is really fascinating, it may seem a little inside baseball, but it's actually very, very important. Mark Meadows ran almost immediately to federal court with a request to remove the case to federal court. Now, people may ask, well, wait a second, I thought this was a state court case. How can it go to federal court? I know two of them are in federal court, the one in the Southern District of Florida regarding the wrongful retention of the national security documents at Mar-a-Lago. And, of course, the one in D.C., which involves 3 conspiracies, and of which this Georgia case can be sort of thought of as a subset. But a state has a right to bring a violation of state criminal laws in state court. But an officer of the United States has an argument that his or her case ought to be removed and tried in the federal court. The idea is that they shouldn't have to run the gauntlet in a hostile state court environment when they're a federal official. This comes up, Mark, a lot with, let's say, FBI agents. And you can think of it kind of 2 different ways. Maybe the locals are very hostile to what the FBI is trying to do. So they prosecute the FBI agent for something that's within the course and scope of his or her duty. That case, classically, if the state tries to do that, gets removed to the federal court. But of course, if the FBI agent gets into a bar fight, he got into a bar fight, and he gets prosecuted in state court like anyone else who got into a bar fight. So the argument is always that it's kind of beyond the course and scope. And that's going to be the argument by Fannie Willis down there. She'll oppose that request to have the case removed to federal court. And she'll say, no, wait a second. Him going down and traveling into Georgia and trying to attend a private counting, a non-public counting of the vote from which he then had to be excluded, was not part of his official duties. But you can see it can be kind of a slippery slope. Mark Meadows will say it was. He said in his petition to go to the federal court and to have it removed. He said that I was reporting back to the president. I mean, the sitting president would want to know. I mean, not this one, not with the allegations that were made, but I mean, theoretically, a sitting president would want to know, is this count going to change the result or not? A rational, conscientious president might want to know what's going on so he could really start the transition, so he could start the story that it's the big steal if it's not so. And that's Meadows' story, that he went down there to see what was what. He tried to do some work on the ground so he could report back. And here's what's ironic about his removal petition. He claims that he told Trump, it's all being done extremely well. It's all being done extremely professionally down there, which, of course, is a nail in the coffin of Trump as part of his big lie, as part of knowing that what he was propagating was false. And yet he kept propagating it anyway and putting out his story anyway. But I'll tell you this, I don't like to make these predictions. And this one is very, very hard to predict. They're going to have an evidentiary hearing, and we're going to see if Mark Meadows has a right to have the case removed to federal court. And here's all I would say. Can I just talk one more minute on this?
Yeah, of course. And I just want to ask you, though, because when you mentioned evidentiary hearing and you're saying they're going to have it, well, in Georgia, we'll see it, right? Will it be televised?
No, because the evidentiary hearing will be in federal court where the federal judge, everybody always points this out, appointed by Obama, the federal judge appointed by Obama is going to have an evidentiary hearing, but it will not be televised, just like things, unfortunately, are not televised in federal court. But what a federal judge does when a federal judge gets a matter, first to look, has the U.S. Supreme Court opined on this issue? Turns out the Supreme Court opined on this issue, but like over 100 years ago, in a very interesting case where a marshal was protecting a U.S. Supreme Court justice. And it didn't say that the U.S. Supreme Court justice was entitled to protection, but this particular U.S. Supreme Court justice, it was Fields, and it was in California, was attacked. The marshal killed the attacker, and the state wanted to go after the federal marshal. The U.S. Supreme Court said whether it's clear in the law or not that a U.S. Supreme Court justice traveling around the country is entitled to protection or not, it sure looks like this marshal was acting in the scope of his duty, even though the law, right, didn't say that a U.S. Supreme Court justice was entitled to marshal's protection. But the more recent case is in the 11th Circuit. This judge will be bound by the 11th Circuit. So if he looks beyond the Supreme Court, he'll look at 11th Circuit law. And that was an FBI agent who was doing a sting. And as part of the sting, they were going to bribe a corrupt state prosecutor. The state prosecutor turned around and indicted the FBI agent. That was back in the early 80s. And a unanimous decision by that 11th Circuit, which will be the circuit that will govern this judge in federal court in Atlanta, who's going to have to decide on this removal matter, said that no, it was clear that the FBI agent was acting in the course and scope. He'd gotten approval from his supervisor. He's gotten approval from his supervisor's supervisor. The supervisor wasn't in any trouble. The supervisor's supervisor wasn't charged with anything. And the FBI agent was acting in the course and scope. Now, by contrast, Meadows cannot turn around and say, well, I got proper approval from my supervisor. His supervisor, ex-President Trump, is in the same pickle that he's in, right? And
Sure.
We're expecting that Trump is going to sit back. He has 30 days from his own arraignment. So he has about 40 days or so. Trump will decide, he'll have to decide whether he wants to make that removal motion. I can't think of any reason why Trump won't make that removal motion. He'll try to get the matter in federal court, but he has this 30 or 40 days mark to see how it plays out, how the evidentiary hearing goes. In other words, Trump will have this all in the rearview mirror when Trump has to decide exactly what he's going to do. But I'm trying to answer your question, Mark, by saying this. However that case comes out, and I think on balance, it probably will come out that they won't remove it. I think there'll be an appeal right away to this 11th Circuit, right? And they'll argue this old precedent. And then I think there'll be either an appeal or a request for a hearing by the U.S. Supreme Court. My point being, huge delay, because one of the things they're asking for is a stay. They're asking for a stay of everything that happens in state court while this all gets batted around in federal court. That's just the first issue in the case, Mark, that might get batted around for months and really paralyze the state court proceedings.
That's fascinating. That really is fascinating. And you had commented before that Trump, because we addressed this issue right away. We addressed two issues, just to remind everyone, but this was one of them, that the removal thing will not work for Trump. But Meadows might have an argument, at least an appealable argument, is kind of what you're hinting at?
You have to be a federal officer or somebody clearly deputized by a federal officer. The others may come in and say, well, I was really deputized. I thought that I was, but they're going to lose. They're going to lose. They weren't getting a paycheck from Uncle Sam. Meadows is probably the best case to start off with. He was getting a paycheck from Uncle Sam. He was the White House chief of staff at all of the times that he's alleged to have committed state crimes. So that's why I say his is, I just have a feeling that if his case goes all the way to the U.S. Supreme Court, that 5 justices on the Supreme Court, and you know who they are, are going to hold in his favor. So not just his, but also Trump's. And I want to say just one more thing.
Oh, wait. You think that if it goes all the way to the Supreme Court, that those justices, that loaded court, would rule to take this case for Trump to federal court also? Is that what you just said?
Why do you think not? He was getting a federal paycheck and was the president of the United States at the time that all of these things happened. See, their argument's going to be that Meadows and Trump acted for the campaign. They didn't act in the course and scope of their office. But, you know, they did act in the course and scope of the office. The only question is, you know, did they far exceed it? You know, that's the thing, especially with Trump. It was so excessive, this intervention, that, you know, this election interference with a state election, which is what Georgia is. Even though it was the presidential vote, it's managed by the state. But you have to make a plausible claim. Will the U.S. Supreme Court say that Trump and Meadows made a plausible claim? Now, Giuliani was not an employee. Eastman was not an employee. I think all of those people are out of luck. But Meadows, and that's what I'm saying, Trump is going to see how the Meadows case goes, you know, and then he'll plan his strategy behind it. But he has another 40 days to make his removal motion. The fact that Trump hasn't asked for removal to federal court doesn't mean he's not going to. I think it's inevitable, Mark, that he'll ask for it. Trump will.
The other thing that we talked about, but just to address it quickly, and then I want to ask you quickly, gosh, I don't know, another minute or so, David, but I want to ask you about the jury and poisoning the jury pool, which seems to be like an agenda item. I'll get to that in just a second, but I want to just address the fact that in 8 weeks, because of this new Georgia law, they could conceivably decapitate this entire thing by getting rid of and replacing Fani Willis with someone else. That the governor can do that. This new law goes into effect, I believe, in 8 weeks' time. Now, you would mention that you didn't think it likely, just because you felt as though Kemp wouldn't want to, it may not represent where he is politically. I don't know if you said that, but you did say that you didn't think he wanted to get involved in the case that way, as I recall, right?
I said both those things, that I think it would be a political earthquake to try to remove her. And I don't think Governor Kemp, who's popular down there, and has staked out his position that the vote was completely fair. It was counted and recounted. Trump lost his state by 12,000 votes with no hanky-panky, with nothing strange going on. And, you know, he and Raffensperger have really taken the position that Trump then tried to interfere and did exactly what Fani Willis is saying. I think their position is that, well, everyone's innocent until proven guilty. They've certainly, you know, suggested, they've signaled to me anyway, that they think that, you know, Trump went way out of bounds. And that's going to be kind of just in lay terms, you know, on this whole removal thing. Was this way out of bounds? Was this not something that was really part of his presidential duties? And it hurts Trump and it hurts Meadows that counting the state vote is not a federal responsibility.
I'll ding hanky-panky. I want to ask you, David, to finish. Is his get-out-of-jail-free card, Trump, and by extension all the rest of them, is his get-out-of-jail-free card to so poison the atmosphere and muddy the atmosphere around this trial that the jury, it will be impossible to seat a truly impartial jury, or a jury that would come up with a verdict in this case? Like a hung jury would be more likely, given the way that he's trying to muddy the water. Is that the plan, or might that be a plan? Is that an effective plan?
That's certainly part of the defense plan. You know, there's an old saying that the prosecutor wants everything to go right and the criminal defense attorney just wants anything to go wrong. So one of the things that could go wrong is a hung jury. One of the things that could go wrong is that the case drags on and on and on, that maybe Fani Willis, they beat her in the next election. Believe me, they'll try. They'll try to beat Kemp in the next election. They'll probably try to stack those state parole boards and see if they can get the state parole or probation board or something like that to do something in their favor. They'll try to change Georgia law. They'll try to somehow remove her. But with all of that said, once the case actually goes to trial, which I think is going to be after 2024, after it goes to trial, I don't think Trump has any defense. I think that on the evidence, this was so outrageous, and they had the phone call. That's an amazing thing, you know. I used to say when I was as prosecutor, you wanted to have three things if you possibly could. And one was a phone call. One was the defendant on a phone call saying clearly incriminating things, which they have on Trump in this case. It's a great thing. The other thing is sort of a pattern of behavior by a criminal defendant where they can't credibly argue to the jury. And you know, by now, Trump cannot credibly argue to the jury. I mean, he's a rogue and a scoundrel. The remarkable thing is that his base seems to like the idea of having a rogue and a scoundrel. Like only somebody with his terrible temperament could, you know, stand up to the woke mob or whatever their narrative is.
Yeah, it's the own the libs trial, but you're right. That's kind of what they've rallied around. Love our time together. Thank you, David. Look forward to next week, and appreciate you always being available for us. You're just the best. Thanks. David Katz, everybody. Hi, it's Mark, and I thought that was great. Hit the notification bell. You'll know whenever there's a new video being dropped, and please subscribe to our channel to help us save the universe.